Hello. Well, it's 2 o'clock, and so I will ask the hearing to come to order. I just want to make everyone aware that about 2:10 there'll be a vote called, but I think we'll have time to get started. And so I want to just begin by welcoming our witness, SEC Chairman Mary Jo White. Thank you for being here today, and congratulations on your confirmation. The SEC has the unique and critical task of protecting investors, maintaining fair and efficient markets, and encouraging capital formation. And these are things that touch the lives of many and have a profound and far-reaching effect on our domestic as well as our global economy. Since 2001, Congress has provided the SEC with additional regulatory tools and has drastically increased the Commission's annual appropriation. And yet, the agency has missed major investment frauds like Madoff and Stanford, as well as several embarrassing management lapses such as purchasing unneeded space, destroying investigative documents, and repeating material weaknesses in the SEC's own financial statements, just to name a few. And so while the SEC has made some progress in addressing these lapses, I believe that some of these problems are symptomatic of the fundamental problems within the SEC's organization and structure. And this committee is not inclined to throw more money at the SEC until these fundamental problems are addressed in a meaningful and comprehensive way. The fiscal year 2014 request proposes another substantial increase of 27% over the fiscal year 2012 and a 33% increase over the sequester amount. And just because the SEC is funded by fees and does not excuse the Commission from rigorously managing the funding it has, and it certainly doesn't discharge this subcommittee from providing serious oversight. So I look forward to hearing how the Commission, under new leadership, intends to provide investors with confidence in the markets, take strong enforcement actions against individuals committing fraud, help facilitate access to capital for American businesses, and to effectively use and manage the resources provided to you to run your operations. The SEC is facing many challenges, including finishing up the Dodd-Frank and Jobs Act rulemakings, modernizing the technology systems, and thoughtful in tackling these challenges. So I think there are a lot of rulemakings still left to be completed, and I hope that you will take a measured and thoughtful attitude toward that. Chairman White, we recognize that you have a very difficult job, and we know that you and your staff are working hard, and we appreciate your efforts. And as the newly installed chair of this agency, you have the opportunity to make meaningful reforms and significantly impact the management and efficacy of the Commission. We appreciate your willingness to take this challenging position. And your experience, both as a prosecutor and in the private sector, should be very useful to you as you work to improve the Commission and the functioning of our securities markets. So we look forward to working with you in partnership and with you on these challenges. We look forward to your testimony. And now I'd like to recognize Mr. Serrano, the ranking member, for any opening remarks he might make.
Thank you, Mr. Chairman. I also join you in welcoming the new chair of the Securities and Exchange Commission, Mary Jo White, before the subcommittee. I must admit publicly that I was pleased when President Obama announced his nomination of Chairman White as the new head of the SEC. The SEC is our cop on the beat for Wall Street, and its enforcement and oversight duties are of the utmost importance in preventing another financial meltdown. I'm heartened that we now have a former U.S. attorney leading the agency, because I believe you understand the importance of these core missions in ensuring the safety of our financial markets, preventing abuse of investors, and in deterring future misconduct. Unfortunately, we cannot discuss the fiscal year 2014 budget request without talking about the elephant in the room, and I'm not referring about my Republican colleague. Congress' failure to come up with a comprehensive solution to sequestration. For the SEC, the sequester has resulted in a cut of $108 million in fiscal year 2013. Although the SEC has been able to avoid furloughs and layoffs, those cuts have come at the expense of your core roles: oversight of our financial markets, enforcement against those who engage in wrongdoing, and implementation of the mandates that Congress has given to the agency. Based on the Ryan budget passed by the House of Representatives, in all likelihood, the agency's budget is going to be reduced even further in any legislation proposed by this subcommittee. I hope you can discuss the impact of the cuts that you have already endured, as well as your views on further potential cuts to the SEC. I feel confident that we share a similar opinion on this subject, that it is an unwise investment choice to reduce funding for an agency that plays a key role in ensuring a fair playing field in our financial markets. Your agency's budget request of $1.674 billion in fiscal year 2014 seeks to invest in efforts that will improve the operation of your agency. Moreover, the budget request will help continue the implementation of Dodd-Frank financial reform and will ensure that the agency has the resources needed to address your expanded oversight role. Your testimony does a persuasive job of laying out the case for the necessity of these increases, and I hope that my colleagues will take this request to heart. Although you have only been on the job a short time, I look forward to getting your thoughts on the SEC's current and future challenges, and once again, we welcome you. Mr. Chairman, the elephant comment was about the GOP. It wasn't, there might be some young folks in the audience that didn't get that.
I didn't get it. Anyway, thank you, Mr. Serrano.
Thank you.
I'll now recognize Chairman White for an opening statement, let you know that your written statement will be included in the record, so please, the floor is yours.
Thank you very much. Chairman Crenshaw, Ranking Member Serrano, and members of the subcommittee, I too look forward to working with all of you as we go forward. And thank you for this opportunity to testify in support of the President's fiscal year 2014 budget request for the Securities and Exchange Commission, and to discuss how the SEC would effectively use the $1.674 billion requested to support additional staff, technology, and training needed to fulfill our mission. First, to acknowledge Public Service Recognition Week, I would like to express my appreciation to all public employees for the work they do every day, and particularly to the staff of the SEC. Although I have been at the agency less than a month, I've been struck by their incredible commitment, talent, and expertise. Our markets remain the envy of the world in large part because of their work writing effective regulations, ensuring comprehensive disclosure, and vigorously enforcing the securities laws. In addition to enforcing those laws, the SEC currently is charged with overseeing 25,000 market participants and reviewing disclosures of over 9,000 reporting companies, a range of responsibilities that has increased considerably with the passage of the Dodd-Frank and Jobs Acts. With the resources provided by Congress in recent years, the SEC has bolstered its examination and enforcement functions, enhanced its technology, and made important internal improvements. Much more, however, remains to be accomplished. The SEC's current funding level presents significant challenges as we seek to keep pace with the growing size and complexity of the securities markets. If enacted, our request would permit us to add approximately 676 new positions to improve core operations and implement the agency's new responsibilities. While our funding is fully offset by securities transaction fees and thus will not impact the deficit, we fully understand we must seek to use appropriated funds in the most efficient and effective way possible. More specifically, our budget request would allow us to expand oversight of investment advisors. The number of registered advisors has increased by more than 40% over the last decade, while their assets under management have more than doubled to over $50 trillion. Yet during fiscal year 2012, the SEC was able to examine only about 8% of registered advisors, and over 40% remain to be examined for the first time. Although we have at the agency employed more risk-based analytics to target advisors selected for review, and those advisors examined in fiscal year 2012 represented 20% of the assets under management, significant additional coverage is essential. This request would permit us to hire 250 additional examiners to increase the percentage of advisors examined each year. Our request would also permit us to bolster the enforcement program and continue to send a strong message to would-be wrongdoers that misconduct will be swiftly and aggressively punished. We would focus our enforcement hiring on increased expertise in the securities industry, trial attorneys, forensic accountants, and staff for the offices of the whistleblower and market intelligence. Our request would also permit 45 additional positions in the Division of Risk Strategy and Financial Innovation, a roughly 45% increase in the size of this essential function. These positions would be used primarily for additional economists to perform economic analyses in support of the Commission's rulemaking and other activities, including economists with expertise in analyzing high-frequency trading data and market structure practices. The Commission's regulatory responsibilities also have expanded with respect to security-based swap registrants. To avoid bottlenecks and unintended market disruptions, we need additional technical staff to process requests for rule interpretation, regulation, and required approvals or exemptions. New staff will also be needed to supervise registered security-based swap dealers and participants. We are also requesting new positions for the Division of Corporation Finance to, among other things, review draft registration statements submitted by emerging growth companies under the Jobs Act and finalize remaining statutory rulemaking mandates. The additional positions also would allow enhanced review of regulations impacting small business capital formation. The SEC's need to invest in technology cannot be overstated. While the SEC is rapidly modernizing our systems, significant investments are needed to properly oversee the markets and entities we regulate. Technology initiatives that would be funded under this request include improvements to our system for receiving tips, our IT security, and our IT infrastructure. In addition, we plan to use our statutorily created reserve fund to fund large mission-critical technology projects, including our multi-year effort to overhaul the EDGAR system and to construct the Enterprise Data Warehouse, which will create a central repository for SEC data and affect significant efficiencies in our ability to fulfill our mission. We are also working to reduce costs wherever possible and have achieved substantial technology-related cost savings in fiscal year 2012 of approximately $12 million, including from initiatives that focused on more robust IT infrastructure, support contracts, and savings in software maintenance contracts. We also seek to increase our training budget to keep pace with the rapidly evolving markets and areas of new responsibility. Effective training is essential to maximizing the efficiency and expertise of our staff. In conclusion, I appreciate your consideration of the President's budget request. Your support for the SEC's mission and its expanded responsibilities will allow us to better protect investors and facilitate capital formation, more effectively oversee the markets and entities we regulate, and build upon the significant improvements the SEC has made to date. Thank you very much for inviting me to be here. I would be happy to answer your questions.
Well, thank you very much. And they've just called a vote, but I think we'll have time for the three members here to ask a question. We may take a recess. I think there's just two votes, maybe three. And I'll call on the members in terms of their seniority, if they're here when the meeting started. Otherwise, I'll call on them when they get here, and we'll go back and forth from side to side. So let me just start by, you gave us a lot of requests, and you go back and look, since 2001, I think the SEC's budget has increased like 300%. And as I mentioned in my opening statement, I think this year it's a 27% increase, 33 if you do it over the sequester number. And actually in 2012, there was $100 million more than the year before that. And so, as you can imagine, most agencies don't get this kind of increase every year. And I know that your budget is funded by fees, and it doesn't come out of the general fund of the Treasury. But we have to take our oversight role pretty seriously. And so we got to ask the questions, how do you think that the average investor has benefited from these large funding increases? And then when is enough going to be enough? I mean, when do you expect that you can stop asking for these dramatically large increases every year? And you touched on some of the things you're doing to be more efficient, but talk about that.
Well, let me say first that we appreciate very much the funding support that we've gotten at the SEC over the years, and seek that support again through this request. I guess one of the things that I have been most struck by since I became chair of the SEC, I should have known this well from the outside, but certainly you know it better from the inside once you're there, is just how vast and difficult and complex the responsibilities are of the SEC. In terms of protecting investors, facilitating capital formation, and really safeguarding the integrity of our markets. Those markets are also changing as we speak every day, and we need to keep up with that complexity and that speed with the work that we do. And so, you know, we're cognizant of these budgetary times. We're cognizant of our mission. We have had additional responsibilities added to that mission, which was already a vast one. And so, we've tried to be as targeted as we can in these requests that we've made, so that it is a responsible request, so we can do our job. In terms of, and certainly I feel extremely strongly about being a faithful and strong steward for those monies on behalf of the taxpayers. I think the agency has also, certainly prior to my arrival, made significant improvements to become more efficient and effective. I think others have testified before about a number of the restructurings in the enforcement and the examination functions, for example. And I think those have really yielded very good dividends. I expect to see more of that. I think those are extremely important functions for the SEC. So it's our responsibility that we have to cover and discharge. It's also our responsibility to spend that money wisely and very effectively. And I certainly am committed to discharging that responsibility.
Well, thank you very much, and we look forward to your bringing a fresh approach as you go about your job. Mr. Serrano.
Thank you, Mr. Chairman. You came in the middle of an uncertain budget year. Between continuing resolution and sequestration, you've had quite a challenge, to say the least. What impact have you seen from this uncertainty and from sequestration?
I think what I've seen is a number of things that I, again, think are critical for the agency to do to fulfill its mission not being able to be done. Certainly, our agency, and I'm sure others as well, have anticipated the possibility of the sequestration. I think our folks have done an excellent job in planning for that, so that we don't expect furloughs, but we certainly have had to defer hiring for some of our new functions and OTC derivatives. We've had to suspend and will have to suspend certain of the critical, I think, IT initiatives that would help our examination and enforcement functions. And so it is quite an impediment to the agency, but I'm glad to say that we're obviously trying to safeguard as much as we can our core mission, but it's very much felt.
You want to?
Mr. Graves have a question, and then let's see where we are. Mr. Graves.
Thank you, Mr. Chairman. Chairman White, well, I guess congratulations and welcome to your new post. I had a quick question in relations to portfolio margining. In your presentation, you spoke a lot about enforcement, and I think we all recognize that as a very, very important role that you have there. But as well, in your statement, you talk about maintaining fair, orderly, and efficient markets. So as it relates to portfolio margining, and Dodd-Frank contained a provision that addressed this, and while there's a lot of controversy with that piece of legislation, a lot I don't agree with. There are certain components that may be beneficial, and this was one of those, one of the few beneficial provisions for exchanges, and that would, I guess, with the portfolio margining would help with the exchanges and with customers alike. And it's my understanding that progress has been made recently in this with regard to permitting of the holding of swaps and security-based swaps in the same account, thus allowing customers to more efficiently use their capital. Can you provide us with an update on the rulemaking activities with the SEC for this issue?
I think I can, at least to the extent of my knowledge. I mean, obviously, a major objective of Dodd-Frank is to promote the clearing of OTC derivatives, such as credit default swaps and others. ICE Clearing Credit has agreed to clear such transactions, which is a very, very good thing. The SEC has issued an order providing relief in terms of some of the margin requirements, looking towards permitting the portfolio margining that is essential and certainly beneficial to the dealers and the customers. Essentially, some of those requirements became effective before all of the information was provided to the SEC in order to be able to approve the portfolio margining methodologies. And so the SEC, I think in March of this year, actually issued letters to, I think, 7 of the broker-dealers to give them stopgap relief. There was some resistance to what the stopgap relief was, I think, in terms of higher margin requirements for the dealers. I could go into the rationale for that, but I think more importantly, the bottom line is that since then, the SEC has been in very productive, I think, constructive discussions with the dealers and with ICE to try to work out what would be an acceptable solution there.
Mm-hmm. Okay, so you are still working on that? It's
Yes,
ongoing.
yes, we are.
Okay, thank you. Thank you, Mr.
Mr. Schronig?
Let me just ask you, as a follow-up to that first question I asked, what are the long-term ramifications from your perspective on reducing oversight because of budget constraints? I mean, one of the big concerns that we have in all agencies is the oversight that will be carried out or not carried out. And the IRS is collecting taxes and going after people who don't pay their taxes. In your case, it's the oversight that we all need now more than ever. What do you think is the long-term effect?
The oversight of the budget process?
Right.
If I understood your question. You know, I think that, and I know there was a discussion before of self-funding for the SEC. It is deficit-neutral funding. That doesn't change the oversight responsibilities of this subcommittee. It doesn't change the responsibilities of the SEC to effectively use those funds. I would hope that.
No, I'm referring to the SEC's oversight of people who may be.
Oh, I'm sorry. I misunderstood your question.
I apologize.
I mean, clearly we need the resources to be able to do that. And we have gotten, you know, a number of, I think I cited, we have 25,000 entities now that we oversee, and we have more coming under the Dodd-Frank legislation in particular. And so it completely, it is essential that we get the funding to be able to do that, or we simply won't be able to perform our job.
Very briefly, Mr. Chairman, and this is in the record, it could be seen. When I was chairman of this committee, one of the surprises was having people from the SEC come and basically tell us, we don't need any more money. We have enough money. We later found out that what that meant was we have no intention of oversight, and many can say that what happened on Wall Street happened in part because we weren't checking. And I don't mean the committee was not checking, the SEC was not checking.
Gotcha. Let me ask you one quick question, and then we'll I think there are 334 people that haven't voted yet, so I think we're in good shape. Let me ask you, we're talking about rulemaking, and the Inspector General has criticized the Commission in terms of the cost-benefit analysis, especially in those Dodd-Frank rulemakings. And you understand that these rules have a pretty big impact on the business world, and that's important, particularly when we've got a struggling economy. And I noticed in your budget request you're planning on hiring some more economists, and I would think that's a critical group for you to hire. And so let me ask you about that. This is a pretty big priority of the Commission to have some more economists. What role are they going to play in this rulemaking process, and are they going to be more active than they were in the past? It seems to me that this is going to be a big step forward.
I think there's no question that economic analysis, including cost-benefit analysis, is essential to our rulemaking function. And you rightly identify our economists as those that are intimately involved in that. The agency, in March of last year, actually issued guidance to enhance its economic analysis of its rulemaking. We've actually gotten some positive comments about the progress in that area, both I think from the Chamber and also in a more recent GAO report, more recent than I think the IG report that you cite, although the agency was quite responsive to all of the recommendations. I think it is essential going forward. This is a very big, it's a 45% increase, adding 45 economists to our risk analysis section, and we get them involved more earlier in the process to judge the economic impact of a rule, whether there should be a rule, what the alternatives should be, whether there should be one at all, as I mentioned. It's absolutely critical. I think the agency is totally committed to the robust economic analysis of its rulemaking, and I think it has enhanced itself, over time in that analysis.
So that's encouraging to want to be sure that, and I'm sure you are aware of how important that is, in terms of the folks that you regulate. Now, some of those suggestions by the Inspector General, I guess you don't agree with everything, but some of the criticisms they had, are you trying to implement those?
I'm not sure precisely which ones we were speaking of, but I know that the agency was responsive to a number of recommendations by the IG with respect to enhancing economic analysis. I think they've been responsive to recommendations coming from a number of quarters doing that, and certainly I would be responsive to recommendations that obviously that I agreed with, but nevertheless it is a priority that our economic analysis continue to be robust and if need be enhanced as we go forward.
Great. Well, I think, Mr. Grant, do you want to ask a question? I think why don't we, the clock has run out, but we are pretty fast. And so we'll go over, and I know some of the other members, probably we're going to wait till after votes to come. And so it may be 15 or 20 minutes, but with your great understanding, I'm going to recess the committee for a short period of time.
I appreciate that. Thank you.
Thank you. I'll call the meeting back to order. Again, thank you for your patience. I think some members may be straggling in from time to time. Let me just finish up one of the things that you and I were talking about, the rulemaking process and the economic impact and the cost-benefit analysis. One thought I had, I don't know if this is something you all do, kind of a look back at the rules and regulations, that from time to time, once a rule is promulgated, that maybe after a year or two, that you kind of review that rule, see if it accomplished what you wanted to accomplish, see if it cost what you thought it might cost. Is that something you all thought about, or would that be a good idea to just, I know everything's changed, as you say, and you got to look to the future, but would it be helpful to look back and see, make sure there aren't any unintended consequences, make sure that things are working out the way you had them planned?
I think with respect to that we rely on a very robust post-comment period as well from the parties affected by the rules. I mean, it's not a formal notice and comment, after you adopt the rule, and certainly you want to remain on top of your markets and impacts of your rules. But I think primarily we rely on the input that we get from our own monitoring of the rules, as well as comments we get from those affected. But I think there was actually a GAO study in 2007 that suggested that actually prescribing a formal look back might not be as efficient, as actually sort of receiving input from those affected every day. So we certainly are cognizant of that, but there's not at least to my knowledge, there's not a formal program to do that. But we certainly do, monitor our rules, and we're in constant dialogue with those we regulate.
Yeah, and I think that makes sense. I wasn't suggesting that some sort of, official procedure take place, but it sounds to me like that you're doing just that, A, when you promulgate the rules, and B, as you just informally look back and you see if they need to change or see if they are working well. So I think that's good. Let me call on Mr. Serrano. But why don't, Mr. Quigley wasn't here, and he just got here, and why don't we do that? Even though Mr. Serrano was here first.
No, let Mr. Serrano go first. That's fine.
Mr. Quigley insists that Mr. Serrano go first.
I've never been so loved. So the big issue that we always continue to discuss in Congress, or at least among ourselves, is, can what happened in 2008 happen again? And what role can the SEC play in making sure that it doesn't happen? And we come back to the point of, can you do that? Can you, without getting all the staff positions you need? We know that we're in a budget cutting situation, and some folks think you cut right across the board. But all agencies, of course, are important. But this is the one that has to keep an eye on making sure that which caused such a huge problem in our economy doesn't happen again. What can you tell us about that?
There's no question. Obviously, none of us want anything like that to happen again. And I think there's also no question, I can say this, I think as the relative newcomer as chair to the SEC, that I think the SEC is absolutely critical to seeing that it doesn't happen again, critical to our markets in general. And also, I think we're given over 90 rulemakings under the Dodd-Frank Act, designed to prevent that, frankly, by greater regulation. And so it's critical that the SEC be able to carry out those rules as well as those under the Jobs Act. And without the resources, it makes it very, very difficult. And then even once adopted, those rules have to be implemented, enforced, monitored. And we have, new regulated entities, registered entities, coming on board all the time that are really quite resource intensive. I mean, that's one of the effects of sequestration, is that we're not able to do as much as we would like to do to build for those new entities that we oversee, and it's critical that we be able to do so.
Briefly, how many rules are we talking about, and how many are in place already or ready to go?
The SEC has, under Dodd-Frank, has proposed or adopted about 80% of the rules under Dodd-Frank, but that doesn't mean all adopted. So there are a lot that remain to be done, including the Volcker rule that there's been a lot of discussion about. And under the Jobs Act, those rulemakings remain to be done. And one of my highest immediate priorities, as I said at my confirmation hearing, is to get those congressionally mandated rules done as promptly as I can and as well as I can.
Thank you.
Mr. Bonner.
Thank you, Mr. Chairman. Madam Chair, I apologize for being late. And so if I'm go into two questions that have already been covered, you're welcome to refer me to the record, and I'll be happy to go there and not ask you to repeat yourself. The first one deals, and I know you've only been in your current position for a couple of months, so thank you for your public service and your career of public service. But the first goes to the Stanford victims. And like many members of Congress, I have some in my district that I have met with and felt their frustration, felt their loss, felt their hopelessness that they were not being adequately looked after by their federal government that they have paid taxes to all these years. The SEC, as you know, recently lost a lawsuit against SIPC in federal district court, which it had pursued on behalf of the Stanford victims. They allege that the SEC, or at least the ones I have talked with in Alabama, failed to properly make their argument, and specifically that they improperly agreed to SIPC's incorrect stipulations of a particular set of facts. The Stanford victims that I have met with over the years agreed to SIPC's incorrect stipulations. They argued that the SEC had agreed to SIPC's stipulations contrary to the fact that for many Stanford victims, these stipulations were simply not accurate. So the constituents I have, in particular Craig and Cynthia Nelson of Magnolia Springs, Alabama, which I would love to have you come down and visit. It's a beautiful little community. They are concerned that with the SEC agreeing to stipulations that were not supposed to have agreed to on behalf of the victims, that it jeopardizes their ability going forward to recover funds. I know the SEC has appealed the district court's ruling, and so technically it's still up in the courts. But if you had an opportunity to visit with my constituents or others from wherever of the 50 states and territories, as Mr. Serrano likes to remind us, if you were sitting down with them, what would you say in terms of the SEC's handling of this to date?
Well, first I would, obviously express, as I'm sure you and many others have, the deep regret that they've suffered the loss that they've suffered. I mean, this is obviously a huge Ponzi scheme with pervasive illegal conduct that harmed many, many people. I think with respect to the SIPC issues and the lawsuit, my understanding of that is, and I have looked into it actually, at least to some degree, is that I think for the first time actually in the SEC's history, and this was really in pursuit of trying to redress the harm that were done to your constituents and other investors, instituted an action to require the initiation of a SIPC liquidation. That's the lawsuit that the SEC lost in the district court. Lost it, as I understand it, on a legal theory. I think essentially unrelated to the factual stipulations that you're referring to. Certainly, as I understand those, either unrelated to the legal theory or consistent with the legal theory. The SEC's legal theory essentially being that even though your constituents may have invested in let's call it the Stanford Bank rather than the broker-dealer, that in effect the broker-dealer, which is covered by SIPC, constructively had their monies too, which would mean that they would be covered, by the SIPC Act. So that is something that we obviously disagree with the district court's decision in that. The SEC really did and has and will continue to pursue that very, very aggressively. But I think from what I know of the litigation, that's how it came to rest where it came to rest, and now it is on appeal. So it is, and the SEC is obviously pursuing that vigorously.
Shifting gears, thank you. The organizational structure of the SEC has been a longstanding problem, certainly long before you arrived in your current position, with more than 20 different divisions and offices all reporting directly to the chair. In the 2010 report, the Boston Consulting Group identified the need for a significant reorganization as one of 4 priorities, and it's my understanding that the SEC has submitted to Congress 3 of 4 reports on implementation of the BCG recommendations as required. Yet to date, the only reorganization the SEC has undertaken has involved an administrative support of offices, as I understand it. So, 2 observations and a question. One of the major issues identified by the Boston Consulting Group report was a lack of a formal structure to resolve disputes between major SEC offices. Can you tell us what actions you will take as the SEC chair to address this silo problem that exists under the current SEC structure? And secondly, as the new chair, will you act on the recommendations of the Boston Consulting Group and undertake a comprehensive reorganization of the operating divisions of the SEC? And I will say at the outset, being from Alabama as well as the state of Florida where the chairman is from, distinguished chairman, the SEC in our part of the world is the Southeastern Conference. So I know the difference between the two when I ask the question.
I actually asked for that job, but no one would give it to me. So, but let me just say that I think the 4th of those, which is the final of those reports, I think was just submitted to Congress, from the SEC. And my understanding is that there were essentially 20 sets of recommendations for new initiatives, including some of the restructuring recommendations that was made by the Boston Consulting Group, and 16 of those 20 have actually resulted in an implementation plan. And the other 4 are continuing to be worked on. My further understanding is that in terms of some of the restructuring suggestions, actually before the Boston Consulting Group was retained, the enforcement and examination divisions of the SEC underwent significant restructuring, I think, to very good ends. I mean, it's clearly something has been there actually barely 1 day less than a month, I guess, but it'll be something I'll be looking at, across divisions. And then, and again, responsive, I think, to the recommendations as well, each of the other major divisions has a managing executive now, too, which has, I think, been a real management enhancement, and that grew out of that review as well. SEC has moved on to what I would call the support operations of the organization. And one recommendation, for example, from the Boston Consulting Group was to merge, in effect, the executive director of the SEC with the COO's office. That's been done, I think, to very good end and very good efficiencies. I'll be looking, across the agency, obviously, for further enhancements and improvements, but I think the SEC has made significant progress based on those recommendations and their own initiatives. In terms of siloed information, I mean, that is obviously something that you need to deal with in any organization, because you will not function effectively with the silos. I think my management style is to break down silos anyway. I think my predecessors achieved a lot of progress in that arena as well, and certainly I bring everyone together to do that, and hopefully walk the talk and talk the talk as well. So I look forward to doing it.
Thank you, Mr. Chairman.
Thank you. Mr. Quigley.
Thank you, Mr. Chairman, Madam Chairman. Last year, as you know, we passed a couple measures that required companies that file with the SEC to disclose information about their dealings with Iran. The first question is, do you have the resources to make sure that there's compliance with that requirement, those requirements?
Again, one of the divisions where we're seeking, I think, 25 additional positions is the Division of Corporation Finance, which actually is the division charged, with that review. The requirement became effective, as I recall it, February of this year in terms of filings made,
Right.
And I think we have received now, if I have my number right, 242 such filings to date, and I think that's really up to date. Somebody gave me the number, I think, yesterday or today. The Division of Corporation Finance reviews them. We also require that that those making those disclosures give notice on EDGAR they've made such a disclosure, so that that helps one, not lose it in the bulk of the disclosures that are made. We then make give immediate notice, to Congress, the President, Treasury, and the State Department, so that they can pursue that. So it's an area that, we certainly are carrying out our functions in. It's obviously a relatively, new set of disclosures that we're reviewing for the last few months, but very important that we do so.
Well, and let me know if I'm mistaken here, but I've had people address concerns that Chinese energy firms, 2 of them, have failed to meet the specific requirements about these level of disclosures that they have with the government of Iran. Is that your understanding, and where are we at with that issue?
I don't, but be happy to get back to you on the specific instances that you mentioned. I mean, clearly as a process matter, what should happen if there's deficient disclosure is the usual, comment back and forth between corporation finance and those companies should be occurring. But I'm happy to get back to you on the specifics of that.
I would appreciate it. And last, the SEC recently filed charges against my home state of Illinois. The quote was that the Illinois misled municipal bond investors about the state's approach to funding its pension obligations. Now, for those of us in Illinois, pension troubles are no surprise. There's nothing new, and it continues to be a major issue. But can you elaborate to any extent on how Illinois was able to mislead investors? And obviously this is an ongoing situation, but would setting disclosure standards for municipal issuers help avoid this kind of issue in a more generic sense?
The answer is, I mean, it is a priority of the SEC to sort of deal with the disclosures and, municipal, financing.
Illinois is not alone.
Illinois is not alone. This was the, as I believe is the case, it's our 3rd major action of this kind, and it remains a priority. So they're definitely not alone. And obviously those are just, we're talking about enforcement actions. The SEC has also made recommendations in a report, to Congress about, among other things, enhanced disclosures. We don't have powers over those disclosures as we sit here now, except through the broker-dealers who actually do the financings themselves, but it clearly remains an issue.
And we need to set standards, I would assume you'd think, right?
Well, I mean, clearly having...
I know you don't have the powers, but someone needs to set these standards.
Yeah, no, I think you certainly want that disclosure to be more robust than it has been, and we certainly see those issues, and not just in your home state, in others with respect to underfunded pension plans and other issues, frankly, as well. And it's a market that needs real attention.
I appreciate that, and I appreciate your getting back to us, as you suggested, and following up on the issues dealing with the disclosure of ties to Iran.
Happy to do that.
Thanks for your service.
Really.
Thank you. Mr. Womack.
Thank you, Mr. Chairman, and congratulations, Madam Chairwoman, and I wish you the very best in this position. As you know, the Jobs Act was signed by the President in April of 12, and it provided language in there, provided a year for the implementation of regulations, and it's been a little more than a year. Can you fill me in on where we are in that process? And I know you're new to the job here, but where are we in the process?
Again, what I can say is, and I said it at my confirmation hearing, as I think I mentioned a little bit earlier, but my top priority, I guess I identified 3 immediate top priorities, but is to get the congressionally mandated rulemaking done, and that's Dodd-Frank, but it's also Jobs Act. I'm spending a great deal of my personal time and driving those rulemakings. I can't give you a specific timetable. They're under active discussion with the staff and the commissioners, but I'm absolutely committed to getting them done as promptly as possible.
Well, even though you can't give a specific timetable, can you give us a season, maybe?
That might not tell you anything, I guess, if I gave you a season. I mean, all I can say is that, we are actively engaged in that process.
This year?
As we speak.
Will it be this year?
I certainly hope so.
Okay. Among other things, the Jobs Act had some shareholder registration and deregulation or deregistration thresholds for bank and holding companies. Unfortunately, it did not explicitly extend those new thresholds to the savings and loan holding companies, even though Congress did not intend to treat them differently. And by the way, there has been legislation filed. In fact, it was in financial services today, got a voice vote. But my understanding is that the SEC has the authority to extend the new thresholds to the savings and loan holding companies. Why, at this point, has the Commission chosen not to do that? Is that something that you're tracking?
I am tracking that, and my understanding is that it is still under discussion and consideration whether we can do that by rulemaking. But that is something I'm focused on and will remain focused on. I'm very aware of that issue, and indeed have been discussions as early as this week on it.
Well, let's just, thinking out loud, if there was a positive opinion registered about do you have the authority to extend that threshold, would it be your intent to extend it?
Again, my understanding is and again, I don't want to get ahead of the internal discussions or my legal advisors, at the SEC, but I think.
Hypothetically.
But I think the sense is that this was an oversight, that should be corrected.
Okay, and we agree with that. That's all the questions I have, Mr. Chairman. Thank you.
Thank you. Mrs. Captur.
Thank you, Mr. Chairman, and welcome, Ms. White. Really glad to have you here today and wish you well in your new duties. I have two questions. The first is kind of to provide some perspective. In order to prevent major financial calamities in the future, retrospectively going back to the 1980s and 1990s, can you unwind the market shifts in housing investment instruments that caused the financial crisis and why the FEC failed to capture their risky nature early on? Kind of looking back. And what do you know now that you didn't know then? What could you be looking for? What footprints were out there that for some reason was not caused by an agency that spends $1.5 billion a year?
Well, I think it goes beyond the SEC. I think what folks missed and didn't understand and are trying to appreciate more and trying to regulate better, to prevent that from repeating itself in the past. I think the SEC is predominantly, a disclosure agency, and so one of the things you want to be sure of is that investments tied to the real estate market, securitizations and the like, have the full range of disclosures. That's something that indeed we're mandated under Dodd-Frank to attend to, but something that, and we have attended to under Dodd-Frank, so that the disclosures are out there for people to see. And I think that is, there's sort of the theory of our regulation at the SEC is that good, full disclosure to investors, can prevent a lot of harm that occurs otherwise.
But could you, for those of us who don't spend our time in the financial markets, extending risk beyond what would be prudent, what really happened?
I'm not sure I or anyone can quite answer that. I mean, in terms of the housing market?
Yes. I mean, you had a loan, you had turned into a bond, and then the bond into a security that was sold internationally in tranches. How did that, from an historical standpoint, who started that, and how did it flower inside our financial system without apparently all these regulatory agencies understanding the full nature of how very risky that was? How was that possible?
Well, I think, even again, commissions, committees, and others, experts have spent, a lot of time gathering a lot of information specifically with that retrospective kind of look and come out with actually differing conclusions to some degree. So I wouldn't profess to have, that degree of knowledge on this, to respond to your question. But I would say that, I think the downturn in the housing market is, occurred. I think it did occur to the surprise of many. Why did that happen? If there had been better disclosure, better attention paid to that, would we have caught it earlier? I mean, certainly those are among the conclusions that that others have reached. Why were there securitizations? I mean, again, I think from the SEC's perspective, I mean, we are a capital markets regulator. Investors, make their choices in different investment products. Our job is to make, and it's a big job, is to make sure that the disclosure that they're given with respect to those investments are full and fair so that they can make informed decisions.
So are you saying that the collateralized debt obligations, for example, had no disclosure? The problem was that it wasn't disclosed at some
Oh,
level?
I think there have been many examples, including in the enforcement arena, where the disclosures were not adequate, no question about it. And the SEC's brought a number of, quite important cases with respect to structured products and the deficiencies in disclosure that accompanied them.
Well, don't you think it's awfully important to understand where the system failed in order to fix it?
I think there's no question about that.
How could the government of the United States have missed this?
Well, again, that's a broad question. I know it's intended to be a broad question. It's something that I think it's a multifactored, very complicated picture. I don't think it's a simple one. And as I say, many committees, commissions have spent a lot of time, a lot of investigative efforts on that retrospective look. And plainly, what we're doing going forward is designed, as a government, as a U.S. government, to prevent that kind of crisis from occurring again, and preventing the kind of systemic risk that can be introduced into the system. I mean, that's something that everybody is, not just the SEC, but all the regulators are very much focused on.
Are there not certain types of derivatives, for example, that where disclosure will not be required? They were exempted under Dodd-Frank.
Well, I mean, I think what Dodd-Frank has essentially done is, among other things, has mandated rulemaking to regulate the over-the-counter derivatives market. It was not regulated before, essentially.
But there are some exemptions, are there not?
There are.
Yes, and what might those be?
Well, I mean, there are different exemptions depending on in what arenas we're talking about. I mean, there are various exemptions, for example, from the Volcker rule as well, in terms of proprietary trading. And you don't want to, there are certain exemptions with respect to hedging activities for customers, which is certainly needed to occur, or the market-making exemption. There are exemptions that what you don't want to do when you regulate and respond to a crisis is to over-regulate beyond what you're intending to do, so that you actually cause harm you're not intending to. So it's a massive effort. It's a massive effort that's been assigned to the regulators to sort out with statutory prescriptions, but as smartly as we can, exemptions included.
Mr. Chairman, I know my time is up, but it seems to me incumbent upon all the regulatory agencies in this White House to understand in sheer utter detail where the train started going off the track in the late 80s and early 90s. By the mid-90s, we were already positioned for major catastrophe forward, and the instruments that were created were not detected. It seems to me that there needs to be a postmortem here by important regulators like yourself. And to the extent you could provide to the record, maybe talking with some of your colleagues now responsible for regulation, let us know, looking back retrospectively, where those instruments were created, what year, by which institutions, that ultimately led to very high-risk behavior and instruments that the regulators missed. And when that happened, it just wasn't spontaneous combustion. It was actual actions by individual institutions and very high-risk behavior that was undetected inside our system and has resulted in the largest transfer of wealth in American history, from Main Street to Wall Street, and the loss of a majority of equity, for example, in the African-American community of this country. It is a shift of wealth that is extraordinary. And I think it would be important for the SEC staff and for the commission itself to understand where the train started going off the track back in the early 90s, late 80s, early 90s. And I thank you very much for appearance today. Thanks, Mr. Chairman.
Thank you. Mr. Yoder.
Thank you, Mr. Chairman. Chairman, thank you for being here today, and congratulations on your new appointment. We look forward to working with you. The SEC recently proposed a 650-page rule on the cross-border application of the Dodd-Frank law to security-based swaps. First of all, I want to commend you, Chairman White, for issuing a proposed rule in accordance with the Administrative Procedures Act, which governs the way in which administrative and independent agencies may propose and establish regulations, and mandates cost-benefit analysis and notice and comment from regulated industries. As you may know, the CFTC has taken a different route. It also has regulatory responsibilities for cross-border swaps. However, instead of engaging in a formal rulemaking process under the Administrative Procedures Act, CFTC Chairman Gensler has chosen to issue interpretive guidance without the approval of commissioners. That's resulted in some challenges for those folks that deal in those industries. And we've had major G20 regulators from around the world commenting that the guidance from the CFTC is flawed and will cause major economic challenges in relations between, in terms of regulation between these countries. Because first of all, why did the SEC choose a rulemaking procedure as opposed to a guidance as the CFTC has chosen? What benefits does that offer?
I think I would say in response to that the ordinary course for the SEC is to engage in notice and comment rulemaking. Obviously, we can give certain guidance from time to time and proceed differently. These are extraordinarily, complex regulations. The market is uniquely global. The complexities really are, quite extraordinary. We were pleased to put out, actually unanimously, last week a very robust rule, we think, that is out again. It is out for public comment. We've gotten comment pre-proposal as well. We've been engaged in very active dialogue with the CFTC. We studied the comments they got on their interpretive guidance. We've been in discussions with many other commenters. We will be, now that the rule is actually proposed, including our foreign regulators. We really need to get this right. Obviously, we are, trying to prevent the risk to the U.S., from this marketplace, but to do it wisely and in full consultation and as smartly as we possibly can. It's not easy to do. We are really, we obviously will listen to all views now that the rule is out, but we're quite pleased to put it out last week.
Well, and I appreciate that, and I certainly appreciate the collaborative approach of building consensus that has occurred at the SEC. And I'm very concerned about the CFTC's language, as are certainly foreign regulators. And I guess, what can the SEC do to work with the CFTC to ensure that there's some consistency between these things? Certainly there are unique areas of regulation, and that's why we have both the CFTC and SEC involved in their own separate processes. But as you can imagine, the complexities that exist already in this area of financial regulation, and to have two agencies who may have separate regulations, some of which at the CFTC may make it impossible for foreign regulators to have a role because of the constraints put in place. And I guess, how can you and the SEC play a role in ensuring that both procedures are done in a way in which, since you're regulating many of the same folks, can be consistent in their application?
Our mandate is to, coordinate and consult with the CFTC. I think everybody recognizes that it would be optimal if there was, consistency. The markets are somewhat different. There could be some differences. I would say that with respect to the interpretive guidance that the CFTC has put out, as well as some of what they've said in some of their no-action exemptive measures, there are a lot of consistencies between the SEC and the CFTC. But it's very important to continue this dialogue because it is a uniquely global market with regulators around the world who are in this space and very focused on it. So we're going to continue in dialogue with the CFTC and our foreign counterparts to try to do as best we can to be consistent and put out the best possible rules on this. Carry out the statutory objective, but also take cognizance of how global and complex this market is.
Thank you for that. And I have a question on a different topic, if I might, Mr. Chairman, if I have a couple minutes. The Fourth Amendment, the Constitution speaks to the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. There's legislation being introduced in the House and the Senate related to the privacy rights of individuals related to their email. There have been some agencies that have opined that individuals do not have an expectation of privacy when it comes to their email correspondence. I happen to strongly disagree and believe that Americans expect that their email is not being read by the federal government. And we have instances where this is happening without the knowledge and without any sort of approval process from the judiciary. It's essentially self-executing powers by federal agencies. There's a bill in the Senate. There are bills being introduced in the House related to this. And I guess, first of all, do you think this is an appropriate power that these agencies hold, yours included, that allows these departments to read individuals' emails without any sort of oversight by the judiciary, no check on that power? And if you think about any other situation in your home or in your personal papers, the Fourth Amendment protects those rights, that you, without a warrant or without proper oversight, that we have a reason to expect our own privacy. Do you think that's appropriate, and would you support legislation to restrict those powers in a way that still keeps the investigatory tools of the SEC, but respects the privacy rights of email for the individual?
Well, there's no question that privacy interests are extremely important. I mean, I think what we have actually weighed in on with a letter, I think, if I believe we're talking about the same piece of legislation, is that the SEC, among other agencies, will, in its enforcement function in particular, subpoena emails from individuals and also subpoena them historically from internet service providers. I think that the current legislation, we have a worry from our enforcement perspective, sweeps too broadly there with respect to internet service providers, because it can result in our not being able to issue those subpoenas. There isn't, you could have a system that requires a search warrant for those. I think that some have advocated that. We obviously don't have the search warrant powers of the SEC. The Justice Department has that, where if you got a warrant, you would have to go before a judge before you could do that. But I think we have to be very careful that we aren't really gutting the enforcement powers. I think we have to be very sensitive about the privacy interests, but I do worry about aspects of that legislation.
Well, do you think the current powers the SEC holds are appropriate given the Fourth Amendment right to protection and right of privacy without unnecessary searches by the federal government?
I do.
Okay, well, we're going to have a debate about that in Congress, and many of us disagree, and we think that Americans do expect that they have a right to privacy in their email, and that the idea that the IRS or the SEC or any federal agency would be reading their emails without due cause or without any sort of oversight from the judiciary that we use for every other portion of our lives, whether it be our person, our effects, our papers, our housing, that somehow email would not have the same expectation of privacy, is a real issue for a lot of Americans. I think it's something that Congress is going to debate. We'd love to have a partnership in ensuring that we have a way to continue to have proper investigatory powers, but the status quo is completely unacceptable to many Americans, and I think it's going to be something that Congress is going to have to address.
I appreciate those comments completely, and I want to make sure we're not ships passing in the night. What I'm really referring to is the Enforcement Division's subpoenaing of emails, not reading them real time. So I take your point.
Yeah. Thank you, Mr. Chairman.
Thank you. I think we'll have time if people have another question, but I'd like to ask you one final question, and that's about money market funds. SEC regulates them. I think most people know those to be among the safest investments. You put $1 in, and you're supposed to be able to get $1 back. And so it's a great short-term investment. And as you know, in 2008, during the meltdown, it wasn't the case. They call it breaking the buck. When you put $1 in, and there was a kind of a run on those money market funds, then there was a time when you only got back 97 cents. And I guess there's nearly $3 trillion in money market funds, and I know it's something y'all are thinking about, proposing some rules. And anytime when people start talking about rules, there's concern that somehow that could have a negative impact, could increase the borrowing cost, change the nature of the instrument. Can you just comment very briefly on what your view of that is? is that something you take into consideration as you try to, you know, safeguard there? And also, are there any other short-term vehicles that you know of that would be alternatives? Because these are used, as you know, by individuals, by businesses, by state municipalities. Talk a little bit about your view of reform of the money market funds.
First, I agree that they're very important products, both to investors and those who engage in, our companies who engage in short-term borrowing. You cite the incident in 2008, obviously, that caused, you know, great concern and, you know, runs on the funds, so to speak. And the concern is the systemic risk, and also that retail investors may be late to the party in redeeming, and so you need to sort of deal with those phenomena. And the SEC in 2010 actually did engage in rulemaking, which I think did increase the resiliency of the money market funds. We are engaged in further discussions about further reform that I'm expecting the staff to make recommendations to the Commission in the near future. But as we do that, we first have gotten, talking about economic analysis, we've gotten from our economists at the end of last year an excellent study that was in response to 3 of our commissioners' questions directed to impact kinds of questions, and you know, what may have caused the runs on the fund, et cetera, and what the effect of various reforms might be. And so that's a very important study in our analysis. And we also, as we engage in this discussion and further reform, want to do what we can to, you know, not to harm the product as well.
Well, thank you. I think that's important. As you know, that when the government came in to ensure those nobody lost any money, and that we're kind of through that. But I think that's an important short-term investment vehicle that so many people use, and it's important to our economy. So thank you for that, Mr. Serrano.
Thank you, Mr. Chairman. Chairman White, I think the SEC has been more vigorous than ever in pursuing wrongdoing. However, I'm concerned about the various reports regarding the SEC's settlement policies with those accused of unlawful activities. In some cases, the SEC has obtained settlements with individuals in which they neither have to admit or deny guilt, even though these same individuals have pled guilty to criminal charges elsewhere. Do you think the SEC is doing enough to obtain admissions of guilt in settlement agreements, and do you think the SEC can obtain enough deterrence value from a verdict in which an entity doesn't admit any wrongdoing? And, you know, part of the question will be, if you had all the funding that you needed, could you then devote to trying to get convictions, if you will, or admissions of guilt, or is this just a policy that says that this may be one of the few places where people don't ever have to admit they did anything wrong?
I have several responses to that. I guess first, the no admit, no deny settlement protocol has been used not only by the SEC, but you know, a number of agencies. This is on the civil side. Obviously, the SEC doesn't have criminal powers for many, many years, and I think to very good end in many cases, where you essentially get nearly all, and perhaps all, sometimes more of the relief than you get after you litigated, and you have no litigation risk whatsoever. You get that money to the investors, you know, very quickly. The SEC has actually changed its policy in cases where there's a parallel criminal matter, where the Department of Justice, for example, will get admissions as part of their resolutions with institutions. The SEC, you know, also, at least generally, will get those admissions as well. You know, having said that, I mean, among the many things that I am reviewing as the new chair is that policy and protocol. I understand the desire for accountability, not only by institutions but individuals. But I will also say that the SEC's settlements, whether they're administrative or they are judicial, lay out a very detailed statement of facts. So there's no sort of question about, you know, what the conduct was. But I take your point, and among the things I'm reviewing with the Enforcement Division is that policy.
Well, that's good to hear, because, you know, one of the comments, and again, I mentioned to you some of the comments that we make amongst ourselves when we're on the House floor before a vote or during a vote or whatever, in the elevator, you know, is that 2008 was such a dramatic thing that happened in our country, such a fiscal tragedy, if you will, fiscal crime in many cases. And yet, the feeling from most Americans are that no one paid a price for that other than the investors and the economy and the American people, that no one went to jail for that. So how confident are you that we as a body and you as an agency can convince the American people that folks are not going to get away with something, at least get away with it again?
Well, first, I think it is absolutely essential for not only the SEC's enforcement function, but any prosecutor, any enforcement function to have credibility with the American people, that when there is wrongdoing, there will be detection, there will be aggressive pursuit and investigation, and there will be punishment and accountability. I would say that I think the SEC's, and the SEC, of course, doesn't have the criminal powers, so it doesn't have the ability to put anyone in jail, but I would say that I believe that the SEC's record in financial crisis cases is really quite impressive. It's essentially they brought, I think, cases against 157 individuals or entities. They got either disgorgement or other penalties, $2.6 billion, most of which goes to investors. 66, I think, of the individuals that they charged were CEOs, CFOs, or other senior executives. I think 70%, if I'm recalling it correctly, of the cases against the financial crisis cases against individuals were brought as litigated cases. So that's not a situation where, that began as a no admit, no deny situation. And I don't want to imply that I don't think, even after I review various policies, I mean, I think there is a significant role for no admit, no deny settlements in every civil agency, because it saves resources, you do not incur the litigation risk, and you get lots of money to investors a lot quicker. But nevertheless, I will be reviewing the scope of that.
Well, we appreciate that. Mr. Chairman, I'll have a couple of more questions for the record, but let me just thank you for your service in general to our country, and specifically now in this position. And your challenge, which I am sure you know, is partly due to your success in your other positions that you've held. And so many people have sighed a sigh of relief knowing that someone now is going to really be scrutinizing this situation. And that's the challenge we have as a Congress and the challenge you have personally. But we know you're up to the job, and we congratulate you again.
Thank you very much.
Ms. Capter, do you have another question?
Yes, I wanted to continue and ask, for most of my adult life, people got mortgages as loans. And generally the local bank held it or sold it off into the secondary market. But at what point did that loan, to your knowledge, did it become a mortgage-backed security? The name of your regulatory body is the Securities and Exchange Commission. So I take it that your agency would be particularly knowledgeable about when the instrument turned from a loan to a mortgage-backed security. Am I correct in my understanding?
I'm sure the agency is very knowledgeable about that. I mean, I believe that the securitizations, such as you're referring to, that product began to be used in the 1980s, I believe.
Yes, I would be very interested, for the record, unless you unwind why your ship crashed, you're likely to do it again. So I'm very interested in how that occurred and how it eluded the regulators within the SEC in terms of its riskiness. I'm wondering what happened. And many institutions then having those loans put into some other place and retaining no ownership at all in that loan. What happened, and which institutions would your commission have the ability to identify through its records which financial institutions first brought those deals forward?
I don't know which institutions there are. I think there are public reports that talk about this. I don't think the fact that securitizations were occurring was unknown to the marketplace. I mean, once it developed in the 1980s, I mean, the market was an active one, and I think not an unknown market. I think, again, what I had said earlier is I think, and it reflected certainly in our enforcement cases, is what was the disclosure about those securitization products?
Yes, and there are institutions, I understand one of them is in Illinois, that actually pivoted off of auto securitization into home mortgage securitization. And back about, early 1990s, I think, had the largest fine in American history placed on it by the Office of Comptroller of the Currency. I'm remembering back about $450 million. It was the largest fine ever placed on an institution at that point in American history. So something went wrong there. What is of interest to me is knowing that, how was it that that process was allowed to move forward and not carefully regulated by the SEC since they were securities? What was missing in the law or your regulatory authority? How did that instrument elude regulation? Are you able to tell me that by going back through your legal staff?
We can certainly provide further information for the record in response. But again, I think we're talking about, as we are speaking now anyway, about disclosures about these securities.
Correct.
But we can certainly try to elaborate.
And
on
I'm
that for
trying
you.
to understand, what was it about that moment that created this force inside the financial system that went unregulated? I mean, it's truly extraordinary. I don't remember anything like it in my adult lifetime. And so I'm really interested in how you as a commission viewed that moment in history, the people who were in place, because I think we can learn something from it. And how it avoided regulation, how it went undetected by the SEC for all those years. You weren't the only place, but you do have the title Securities and Exchange Commission. So I'm wondering, was it the definition in the law that was flawed? Was it some mysterious financial instrument that eluded regulation? What happened back then? Could you go back and ask your staff to take a look at that and tell us what occurred back then that allowed for this securitization and the various instruments that were used? I think one was called an RBS, that was a security. I don't know if collateralized debt obligations came under your purview or whether that was over at the CFTC, I'm not sure. But something happened with these very high-risk instruments that went undetected. What was the pattern of that instrument inside your commission? Was it even seen? I'm thinking back, what happened there? Was it our fault as a Congress that something was exempted from the law? I'm wondering if you could provide enlightenment by going back to that period in time and see why those types of securities involved in the mortgage crisis were not regulated by the SEC. I'm looking backward now, not forward. I'm trying to understand what happened. Do you have the ability to do that?
Well, why don't I think what I should probably do is let me see if I can give you a further response after I go back and speak with the staff on this. I mean, again, I think, well, let me do that. Let me respond further.
Thank you very much. And then my second question, my last question for the record. Looking forward, if you look at the cases that have come from the SEC now that have yielded some compensation back to individuals who've been harmed or regions that have been harmed, could you suggest which of those might have been the most effective in moving dollars back to individuals and communities that have been harmed? What were the causes of action that were the most, to date, the most effective in getting justice to harmed individuals and communities?
I think the financial crisis cases that I just mentioned, in terms of the numbers of dollars, I mean, the high volume of dollars, I mentioned $2.6 billion that the SEC's achieved through those financial crisis cases, and either by way of disgorgement or penalties, most of which goes back to investors. I mean, I think those cases have been very successful. I think by definition, you want every harmed investor to get as much compensation as possible. Obviously, we've been talking about scarce, resources, but I think those cases actually delivered a lot of money back to harmed investors very successfully.
Is your commission aware, or could you provide for the record, any communities across this country where, for example, a city, county government, a school district had pension funds or investments that were impaired by certain financial companies that gave them faulty advice or fraudulent advice, and therefore those funds lost money, impacting those communities? To your knowledge, have there been any such investigations by your commission or any communities that have been found that experience that type of loss, and has that been litigated?
I mean,
to your knowledge?
certainly people across this country and all communities can suffer losses at the hands of a securities fraud, and certainly the SEC has brought cases that have pursued those in many cases to achieving a fund for investors in various communities. But I can try to respond further for the record.
All right, I thank you. Thank you, Mr. Chairman.
Thank you. And Chairman White, thank you so much. You have a very impressive background as a prosecutor and in the private sector, and I'm sure that background experience is going to be useful to you as you undertake this new challenge. And we look forward to working with you to do what we can to make this a better place.
Thank you very much.
Thank you for being here today.
Thank you very much.
This meeting is adjourned.